Jennifer, what is your reaction to the decisions and to Chief Justice choosing to write the opinion instead of perhaps Justice Alito or Thomas?
Yes. Well, today, 6 justices joined the majority opinion in full here, finding that it's not constitutional to discriminate on the basis of race and that race can't be used as an independent factor in isolation. Perhaps somebody can talk about race in their background as impacting another aspect of their character or the quality of their credentials. And so it could be looked at in that way as you might look at any other aspect of an individual's character. So it's not disfavoring race over other characteristics, but it's not raising it up as a separate basis as well because of the constitutional violation. I think it's interesting here that in contrast to one of the big constitutional blockbuster opinions of last term, the Dobbs opinion, that the court does not squarely expressly use the language of overruling precedent in its opinion today. And so unlike the Dobbs opinion last year that Justice Alito wrote and the Chief Justice wrote is separately to say that he thought the decision could have been, the judgment could have been consistent with Roe and Casey. Here, the Chief Justice keeps the opinion, writes for 6, and the court is not, it tries to make a little bit more of a show of being consistent with past precedent on affirmative action and applies strict scrutiny here and says that under that standard, these programs just don't measure up.
Jennifer, you've clerked at the court. You clerked for Judge Kavanaugh when he was on the appeals court, right under the court as well. They took a long time to reach this decision. Just the fact that they took the case certainly indicated that they were going to, that they had reasons to want to, take a hard look at affirmative action, or they wouldn't have taken these cases. But do you think that there was a lot of, conference discussions, trading opinions? They took some time to reach this. We know that Justice Jackson was recusing herself on the Harvard case because of her involvement with Harvard University in the past.
Well, certainly. I mean, these cases were argued, I think, back in November or December. So this is not unusual, though. Often the court has these big decisions that people are waiting for, that the public's paying particular attention to, and keeps them until the end of the term. There were separate writings here. So Justice Thomas wrote separately to explain how he believes the decision today was consistent with how the 14th Amendment has always been understood. Justice Kavanaugh, in contrast, wrote to talk about how he concludes that this opinion today is consistent with past precedent. But, in general, at every level that this case has been considered, I think judges have taken a very careful look. The litigation has been around for close to 10 years. In fact, tragically, one of the lead attorneys on the case at the beginning passed away earlier this year from brain cancer. So I think when folks are looking at universities like this with wonderful reputations who are educating a lot of leaders in our society, they're going to take a careful look and evaluate the Constitution and try to figure out now, more than 100 years after the 14th Amendment was ratified, how it applies to challenges being brought today.
Laura Jarrett, Danielle Hawley, Harry Littman, and Jennifer Mascott, thanks to all of you. And